This is criminal litigation drafting series, where we are dealing with drafting questions from year 2008 to 2019 past papers. By example, past papers, which I did not draft in my Q&A at the website. From 21 to 2021 papers, 2022 papers, 2023 I've drafted. And not only are we looking at draftings that have been tested in those years, we're also looking at mock exams drafting, which are for areas which have not been tested, because they can come. And one of the questions that has not been tested is now this. We are now about to look on bail pending appeal, which have not been tested in the past. The only question that have been tested are theory questions. And I said last time that drafting usually tests your skills on drafting, knowing the document, the content, generally the principles, then your timing. So we can look at this question, which I drafted myself as a mock question. Jokayo was charged in criminal case number 800 of 2019 before the Chief Magistrate Mombasa Law Court. He was charged with 2 counts of dealing in wildlife traffic of an endangered species without a permit, contrary to Section 92(2) of the Wildlife Conservation Management Act of 2013, and in possession of a specific trophy without a permit of a exemption contrary to Section 92(4) of the Act. He was convicted by the Subordinate Court to life imprisonment and immediately filed an appeal. His brother, Peter Kayo, has now contacted you to secure the freedom of his brother. Pending an appeal of the case, draft the appropriate pleading. So we are told in the question that he drafted the petition immediately. Now he wants to secure his freedom pending appeal. So it generally tells you that this question is testing you on bail pending appeal. And bail pending appeal. In your question, you must bring the 3 principles. Even before we look at the answer, in your answer, you must bring the 3 principles that you must prove before a bail pending appeal is granted. And what are the 3 principles, Miriam? Miriam? Hello?
I'm sorry, Mwalimu. I think it's that you have a good and arguable appeal, and that's the one I know for sure, because the other one sounds like they're for civil.
Yes, there's a very, very important locus classic case called Jivra Shah versus Republic, 1986. Whether the appeal has overwhelming chances of a success. If the appeal has no chances of succeeding, no appeal. the appeal will be denied, whether the exceptional or unusual circumstances warrant the court to exercise jurisdiction, whether there exists a high probability of the sentence or substantial part of it having been served by the time appeal is heard. Those are the three grounds. This kind of application rarely go through because it is very hard to prove the three factors. You know, there is a policy in judiciary to hear cases very quickly. So it is very hard for someone to have a high probability of the sentence or substantial part of it having been served. So then to this question, what is if you are convicted on with this crime, what is the sentence if you are convicted on this crime of the wildlife conservation? You checked?
Yes, I did. It's life.
It's life.
Yes.
Okay. Oh, both of them is live, eh?
I know the second one is live because I was very shocked to see it.
Okay.
I'm not very sure of the first one, but I think it's the one, it's live, or I think it's an fine of like, it's a very large amount of money. I don't know if it was 12 or 120 million. It was a very large amount of money, or both.
Okay. If you check, that is okay. In fact, I took this fact somewhere online, but I changed some of these. I didn't know if it is life imprisonment, but nevertheless, that is what you should try to do. Let's start with this is rules application. You can do this application in two ways. You can do through a chamber summons, or you can do through a notice of motion, bail pending appeal. But the usual practice, many of the cases that you look online, they use notice of motion. So for the purposes of your exam, use notice of motion. But chamber summons is also right. And it is a miscellaneous criminal application. So now I'm reviewing the answer given by Ruth. In the Republic of Kenya, you do the bail pending appeal in the High Court. So here you change from the Chief Magistrate Court to the High Court, Mombasa Law Court. Miscellaneous criminal application number that of, it was 2019, not 2013. Joe Kayo is the applicant and the Republic is the respondent, chamber summon. Article 49 of course you could, and section 57 of Criminal Procedure Code, that is okay. Let all parties concerned attend in chambers before the Honorable Judge on the day of 2019, not 2013. After that, the application be certified as that the applicant be released on bail pending appeal, which application is based on the grounds. Now bring the grounds that we said. That the applicants are appeal as the decision of the subject are convicted to life imprisonment of 2 counts of dealing without right to endanger species. When you're anytime you're saying application based on grounds, you You bring the grounds, the legal grounds, not the nini, not the legal fact, not facts. Facts you put in the affidavit. So this is not a ground. That the applicant have fixed abode and shall comply with the direction of court in terms of the bail. So if you don't have grounds, both of these are facts. So you can go straight to which application is further supported by the affidavit. If you don't have legal grounds, you can go straight to the which application is further supported by a affidavit of Joe Kayo. And other on the other grounds to be adduced at hearing. Dated on this drawn by filed by PO Box to be served by ODPP. Penal notice is very, very important. And any party served does not appear. For any pleadings, applications, you must put a penal notice. Notice of motion, chamber summons, all of them. A date of the above such a dosa will be made at the position taken out as they may deem fast and expedient. Then supporting affidavit. I, Jokayo, or be a box in the public, or do here make a road as far that there are matters of sound mind capable of this sort, that they are fixed abode in Kenya, that they appear as an arguable case, that I work as a public officer on attendance to go to work at my job, thus I shall be deportable, that I shall adhere to any bail terms fit to attach as a condition for bail, that what is deponent to is best to my knowledge, shown by the sage Oka. This day is 2019. So Ruth tried. The only thing we remove is here. If you don't have the grounds, which application is based on grounds that in the pleading itself, you put legal grounds, not factual things. So you go now to the rule the application. Should not indicate the time taken. Also, Ruth indicate the time taken next time. Miriam says he did the application from 11:10 to 11:37. Those are 27 marks. For a question of 10 marks, that is okay. You was within time. Republic of Kenya in the High Court at Mombasa, okay. Miscellaneous application. Miscellaneous, you put here criminal application. Because it's criminal number of 2023, Jokayo applicant versus Republic. In the matter of High Court, appeal against the conviction and sentence of, in the matter of the High Court of Appeal against conviction, when you do this when you are doing a petition of appeal, notice of appeal, memorandum of appeal, this is not very necessary for applications. Are we together?
Yes, Volume.
Yes, so you go straight to chamber summon under section 353, 57 of Criminal Procedure Code and all enabling provisions. I said you can do this application in an exam, do notice of motion instead of chamber summon, but also chamber summon is correct. Let all parties concerned attend the judge in chambers on 2029 for noon soon thereafter for counsel for the applicant to be heard on, that the application be certified as urgent, that the applicant be admitted to bail pending appeal on such terms as the conditions that the Honorable shall deem fit. Any such other court shall be deemed necessary expedient in the interest of justice. Which application is based on the following? I said here, the grounds that you put on your pleadings are legal grounds. Look at the pleadings that I've drafted in the Q&A, if you don't have the grounds, you can't, here you say, number one, the cases, the principles that you have said, that the principle, that the applicant's case has an arguable appeal. Then there are exceptional and there are exceptional circumstances that warrant the applicant to be released on bail. So you put the legal principles here. But if in an exam that the number one is not relevant, those are factual issues. Number two, that the applicant was convicted of a offense of a magistrate find the instance appeal. That those are things you put in the supporting affidavit. That the applicants are a good and an arguable appeal. That may be a ground, legal ground. So the only legal ground here is number one. The other two are factual issues you put in your supporting affidavit. And you don't, if you don't have them in an exam, you go straight to the supporting affidavit. And further, based on the supporting affidavit by Peter Kayo, it is somebody being in prison does not mean that he cannot swear an affidavit, because a lawyer is allowed to see his client anywhere. So you don't put the affidavit of the blood as the one who swore the affidavit. Is still the person who is in prison. Are we together to that point?
Yes, we are.
Yeah, so
There's something I would like you to clarify for me before we continue. The grounds that are given in Jivraja Shah, I think, versus Republic, there's one I'm not understanding. The unusual and exceptional circumstances is okay. The good and arguable appeal. It's that third one I don't understand.
Is the, you see, if you are convicted of a crime and you are sentenced to 5 years, then before before now you appeal and your sentence is hard and determined, you take, for example, 3 years, you are in prison. So that means you have substantial part of your sentence before the case is hard and determined. Are you together? So yes. So that's why I said it is very hard to prove that one, because criminal cases are hard very quickly in Kenya. Unaona? We now with so many magistrates, and then now the judiciary you know that principles in the fair trial in Article 50. You know that article that says that to start and the trial to start and conclude without undue delay. You know that section, eh? A sabbatical of fair hearing, eh?
Yes.
So to have trial begin and conclude without unreasonable delay, that is article 52E. So judiciary has put measures. So criminal cases that do not stay so long, like Kitambo, like a long time ago. So even if you look at KRR website, the people who succeeded on bail pending appeal, they succeeded based on 1 and 2, not on the sentence part. Are you getting?
Yes, I am getting it now.
So that is it. I, Joka, another to Sunway Post Office address in the Republic of Kenya, do hereby solemnly make those as follows. I'm the applicant's brother, so I'm conservant. So you have said that here you put his name. As such, conversant with the matter, dependent competent to say that the applicant was charged with dealing with. Now you put all the things, the factual issues in the question. It's also with the permit of the exemption contrary with section 92. Possession of endangered species without a permit contrary to section 92 of the Wildlife Conservation Act. That the applicant was convicted of offense by the Chief Magistrate Court and Mombasa and filed an instant appeal. That the applicant has a good and arguable appeal. That the applicant is good and a standing member of the society who will not abscond court and still cooperate with the terms and conditions court shall place on him. That the stated hearing is true to the best of my knowledge and belief. So, shown by the said. So, to improve on your drafting, you should be very creative so that you bring up the principles. For example, you can say that I suffer from diabetes or sijui this disease which make him need constant medical attention. That may be an exceptional circumstances. And you says you have attached the report, the medical report of the doctor.
My concern, Mwalimu, with that, aren't you introducing facts into the question?
No, you are not producing. You are not. You see, you are not introducing facts to the question. You are building or you are filling in your facts to make your case more good based on this. You see, at the end of the day, you are trying to prove this three grounds. For example, even you can say on whether they have chances of success. You can say the way the magistrate conducted the appeal, the trial was not okay, and you put some things there. You are building on these principles. Unaona, you are not changing the question, but you are building on the principles that you make your case more strong. Because at the end of the day, you must bring him these three principles. Are we together?
Yes, you are. If you don't mind, kindly reframe for me how you've put the third. Okay, not the explanation. How have you phrased it? The third issue. The third ground.
You could have said this. You could have said that, of course, theoretically, practically it's not, it's not, but theoretically you can say this. That there are a lot of many criminal cases pending in the High Court in Mombasa, and you have learned that the hearing of cases will start next year on the diary will be open next year, December. And due to the research that you have done, that in many criminal cases, the trial takes about 3 years, and then before the judgment. So the accused or will spend about 5 years before the case is heard and determined. Such kind of things. Are you together?
Yes,
you become very creative to support this point. Of course, practically, that is practically in practically that is not what is happening. Of course, you can look at the case that have been successful. There are cases which have been successful on bail pending appeal, and I just want to give you one. You can look at it later and see how what made the court to grant the appeal. Of course, you can use this case in your even as one of the cases that have been if you have brought this question as in an exam. Drafting is a skill which you perfect it over time. So that one I can share later. Let me write somewhere so that we don't. So we now go to the question I sent you on Friday. Remember, we are dealing with these are topic 9. Topic 9 to 12 of your course outline. We are going to deal with them for some time, and then we are going to deal with the other topics later. So This is question 3, November 2012, which I want to open now. It was the first question. You can hear me?
Loud and clear, Mwalimu.
So, question 3, November 2012, which is on your screen. The following statements was recorded by Sandra Yoga. These topics deal with I think I wanted to open the course outline. It is very, very important. Now that we are done with the bail pending appeal and bail and board topic, those topics involve pre-trial. I don't think that there is a drafting that can come from there. Trial process, the whole trial process, that is topic 10. Then revision, very examinable area. Then appellant jurisdiction, appeal, very examinable area. So we are going to deal with some questions around this 1, 2, 3, 4 topics. Then we are going to go now, the last bit on this criminal litigation. We are going to now, I'm going to combine the other topics, the other topics from topic 13 to 20, all the possible drafting that can come from topic 13 to 20. So, question 3, November 2012 was asked. It was dealing with this topic 9 and then topic 10 on examination of witnesses and all the kind of things. Examination of witnesses, because examination is all those things. So I want to read the question 3, November 2012. The following statement was recorded by Miss Sandra Yoga at police station in Dadora, Phase 1, Nairobi County. This is a statement of Sandra Yoga, a businesswoman. I am a businesswoman dealing with assorted of merchandise. I mostly ply my trade along Tomboya Street in Nairobi. To be precise, I'm a hawker, although I can call myself a businesswoman to give myself some stature. I remember very well the events of 20th September. I belong to a women's welfare group, popularly known as Chama. We have had a meeting in the house of one of our senior Muslim members and founder, Miss Winnie Tuku, at Randmawa in Nairobi. The Chama meeting ended at 7:30 p.m. Since I had taken my Toyota vehicle, my motor vehicle, Toyota Prado to Toyota Kenya for service, I decided to board a taxi to town. The taxi that I boarded twice the South Beach Estate to Nairobi Central District Route. The taxi head around 8 passengers on board. On reaching our stadium, the man seated right behind the driver whipped out a pistol and commanded the taxi to Mukurweni kwa Jenga slums. On reaching the slums, the man accomplices inside the taxi. I think they were two. I think they were too systematically went through each passenger personal effects, taking money and mobile telephone. I lost to the 3 men Kenya shillings 3,000, which I had given to Chama. They also took away my iPhone 3. It was brought by my husband, Mr. Yoga, on our first wedding anniversary last year. The man who was seated behind the driver was tall, slender, and had a scar on his right cheek. The other 2 men were dark complexion, propelled and spoke English with a British accent. The robbers abandoned us in the slum. The other vehicles, the other passengers, and I walked to industrial area police station where we reported the incidents. On 28 September, I was called to industrial area police station to attend a identification parade. I attended 3 different parades. I positively identified the man who whipped out a pistol and 2 of his assistants. I later recorded this statement at the industrial area police station. That is what I wish to state. Draft 7 questions that we would pose for the witness while conducting an examination in chief. So, examination in chief, of course, is where you are acting for the DPP, and you are now going to read your witness to give evidence in court according to the statement he wrote, and of course, he's going to give the story in this question, and we can start with Ruth. These are the questions that Ruth drafted. Examination in chief, it does not indicate the time taken. Always you start with your, when it is examination in chief, of course, these are questions that come in trial advocacy, and a question that can come in civil litigation, and a question that can come in criminal litigation. You start with your name. You start by asking the witness or the complainant, please state to the court what is your name. That is the first question. Where do you work? That is not relevant. That is not a relevant question to ask a witness unless the complaint is related to work. Are we together, Marianne?
Yes, my
Yeah, my internet is unstable, so that's why I'm asking you. This question was not relevant. Then you go straight to this is how you start. You start by telling the witness, tell the facts of the case. I want to open the question. Tell the court the event of 20th September 2012 relevant to this court. After the complaint have given this name, that should be the next question. So he gives the story. Of course, you give the story in brief. I was in the women meeting. Sijui what happened. Then they boarded the matatu, the nini. Then the next question should be now where the next question now should come at because you want to capture to get as the story for convicting this. You suppose the theory of the question according to your trial. The next should come here. On reaching your stadium, what happened? Of course, you don't in the rules of examination in chief, you don't ask a direct question to the witness. So, what time did you board the taxi? Where were you heading? What happened after you boarded that taxi? How many people stole from the passengers? What did they steal? How was their physical appearance of the robbers? Of course, you have been told you should also include after being robbed, what happened? Then, of course, she has tried, but where do you work was not very relevant. 1, 2, 3, 4, 5, 6, 7. So we can look at your answer now. Let me open your answer. The civil procedure rules is not relevant. Not relevant. Pending appeal not relevant. Beyond criminal. So we go to your answer. Examination in chief. This whole question, you says it was a question of 15 marks, if I'm not wrong, and you used you says you used you should use about 38 minutes. So here you used about 405 to 439. That is 34 minutes. So you are on time. That is okay. Examination in chief. Please start by telling the court your full names. That is, it ends there. Where he lives and what you do is not relevant for the question. You don't ask so many. It is very short and direct. Are we together?
Yes, Molly.
Mr. Sandra, on 20th Central at 7:30, where were you and what were you doing? And that is relevant. What happened after you boarded that taxi? How many Assyrians were there in that taxi? What did the Assyrians do on reaching Mukuru kwa Jenga? What essential did it take from you? How did the Assyrians look like? What did you do after the Assyrians abandoned you? Describe their identified Assyrians during the police certification. Tell us if the Assyrians are in this court room and if they are, you can pinpoint who are there, doc identification. Okay. This is okay. You tried. You go to the next question. Cross-examination. Cross-examination, now you are acting for the defense counsel. You must put doubt. Remember, criminal case, you must prove them beyond reasonable doubt. So, your essence here is to your essence here is to put doubt on the prosecution case. And you are told to draft 3 questions which you pose for the witnesses. You can hear me?
Very well, Mwalimu.
Yeah, sawa. So, 3 questions. And here, when you're doing the cross-examination, you are allowed to do reading questions. So, let me see. You can start with Ruth. What he did. 3 questions for cross-examination. You stated you think the robbers were 2. Of course, we don't know the answer is gave. From the answer is gave, you ask another question to put doubt. You are not certain how many people robbed you and the other passengers. You describe one robber, yet it was right. You did not know how many robbers. How did you see one clearly in the darkness? So I think these are questions that are putting doubt. That's okay. She tried. Cross-examination. You stated that you were able to identify the assailants, correct? You stated that one had 2 scars in his left cheek, correct? When the assailant spoke, they had spoken in English with a British accent, correct? These questions are not very clear. Now, they are not putting doubt. You should have said like the way Ruth is saying here. You stated that you think the robbers were 2, or you are not certain how many people robbed you and the other passenger. Describe one robber vividly, yet it was night. You did not know how many robbers. How did you know see one clearly in the darkness? These questions are putting doubt, and yours are not putting doubt. You should have said like you said that you are robbed on 20th September. Then you are called for identification parade on 27th September. That is 1 week. How did you remember between the time you are robbed and the time you went for identification parade? Then you can ask, you know, there are those rules that are followed in the identification parade. You ask him, how was the identification parade conducted? Did the investigation officer or the officer conducting the parade show you the suspect or the accused? Then maybe they say you put doubt. In fact, you can show you are shown the suspect during the identification parade. You are reading to say yes, so that you put doubt the identification parade. Are we together? You are together, Marianne?
Yes, we are together. My class, I think we should be covering that this week. We haven't covered cross-examination yet, but I'll try and correct them.
Yes, you even you can read the witness to answer the way you want. Then because of course they are not lawyers, they don't know how the identification parade should be. Then you read them to say the wrong thing, then you hit them on what they have said because you are the lawyer and you know how the identification parade should be done. So we go to the last question. While leading Ms. Yoga in her examination in chief, what issue did you highlight to confirm that the identification parade process was impeachable? So now you are still the state counsel, you are the prosecuting counsel for the DPP, you are the examination. So of course you know how the identification parade should have been conducted. Now you read the witnesses, and this we covered last time. So let's see what Ms. Yoga said. Ruth said, Ms. Yoga, examination should be highlighted to confirm the identification parade. Three different parades were conducted on the same day, resulting in Ms. Yoga defending the suspect. Recording statement after identification of parade. You should put them as if they are questions you're examining. He did not do that. Whether the investigation officer was involved, whether the view of the suspect of the conduct the identification parade was recorded, the physical appearance of the participant. So he has identified the principles, but he has not put them as questions. M is your answer. Whether an identification parade was conducted for each suspect with 8 persons, similar heights and appearance, whether steps were taken to ensure the disfigurement of the accused with the scar and the right cheek had been concealed, whether you identify the assailant by confronting them, whether the witness be allowed to direct the assailant to speak at the end, whether the rest of the parade was asked to do, whether you saw the assailant before the parade. So you should put them as question. So you should put them as examination in chief question, directing them as the witnesses. You say, for example, how many people did the identification parade involved? So he says 8. Were those people of similar height, general appearance, and age? Eh? Did you identify the accused? How did you identify him? Maybe he tells you he identified by touching. Were you directed by the investigating officer to touch the accused? Of course, you have prepared before the court, and the answer there is no. Did you see the assailant or the accused before the ID parade? Of course, you are prepared. He says no. Are you getting my point?
Yes, Mwalimu.
Yeah, you put them as question to the witness, as examination. Of course, you are prepared before court, and you know the questions she's supposed to answer. So that is it. I'm going to give you, for you to perfect this area, I'm going to give you some other, I'm going to give for the next class. That is what we are going to start with. I'm going to give you some question which you are supposed to ask the witness. Examination in chief questions, cross-examination, re-examination. But this question, I'll take them from trial advocacy for you to perfect this area. But we are going to use them for purposes of this criminal litigation drafting. Are we together?
Yes, Mwalimu, I'll really appreciate. That way I can cover even for trial at the same time.
Yes. There are many there are questions there tested in trial advocacy on the same. And now we go to the next question, which is question 4C, November 2014. We are done with November 2012. We are now in November 2014. Question 4C, and I'm going to read it now. Mr. Abunuasi, Acacia Indodros Livestock Cooperative Limited, was on 30th March arraigned in Bura Chief Magistrate Court criminal case number 11 of 2013, 11 of 2013 on charge of stealing by servant, contrary to section 281 of Penal Code. The particulars of the offense allege that he, Abunuasi Kimasi, on the adverse date between 2nd and 23rd January 2013 at Toro Livestock Office in Moyale Court, where the Republic of Kenya stole various sums of money totaling to that amount, 555,550, the property of Doro Livestock Limited. For the next 1 year, there was an activity in the prosecution witness in the court, in the court, ascribed mainly to instability in the area occasioned by frequent incursion by Al-Shabaab militia into the region. The last time the prosecution presented a witness, one Mr. Abdi Makenza, an auditor, was in 14th May 2014. Mr. Makenza, accused gave evidence in chief, but could not be cross-examined due to shortage of time. Next hearing was fixed on 28 May 2014, but Makenza's cross-examination could not proceed as trial magistrate was taken in. The case was fixed for mention on 11 June 2014, but the date the court was informed that Mr. Makenza had mysteriously disappeared. After a mention was fixed on 11 June 2041, but on the day the court was informed that Makenza's body has been found early that morning lying 100 meters in the bush behind the Hausa State Cooperative Society offices. Information regarding the prosecution case suspicion around the accused one as having had in Makenza's disappearance and death. It was a prosecution views that the proceeding against Kishore ought to be halted temporarily while the police exposed the possibility of obtaining a replacement of Makenza as a witness, concurrently with the investigation into a Kichwangumu's possible complicity in Makenza's death. You are an assistant director of public prosecution in the office of DPP. Draft a suitable and duly supported application for filing in trial. Court informing the court that the Republic does not intend that the proceeding against Abunuasi Kichwa continue.
Mwalimu,
Yes.
I meant to tell you this at the end of the class, but some of the papers, the way you've uploaded them, they don't correspond. Like, for instance, I didn't do this paper because that's not what I found for November 2014.
Yes.
The question I did for it was a charge sheet. So I don't know what happened. Like, I think the 2011 one for criminal is actually a trial paper that's uploaded. Yes, so maybe look at that, because I also got the question, the way I got it was from the question and answer bit, and I'm seeing it's not corresponding to the one you've done. Yes,
you see, your duty is when you see a paper that is been uploaded incorrectly, Ruth usually tells me,
yes,
I'm still cleaning up the papers, and even there are some copies I'm going to ask you to help me. I'm still cleaning the nini, and so you have a duty to tell me if it is not, if you see the paper is not right. So which one are you saying is uploaded wrongly?
the one for sure is the November, the 2011 question. I think it's November 2011. No, 2011.
November
It's one of the
2011.
questions we're meant to do. So on that criminal part, the paper that's been uploaded is a trial advocacy paper for the same sitting, but now it's the wrong paper.
November 2011, and this November 2012, eh?
This is 2012.
November 2014.
Yeah, I'll confirm again on the questions. Maybe it's me who did the wrong question, but I even indicated. So I'm very confused as to what went wrong. I'll confirm again and then I'll let you know by the Thursday class.
Yes, I'm also going to look at written, eh? Yes, November 2011 and November 2015 criminal litigation upload. I'm going to look at it right now. In fact, I looked at your question and I saw you have drafted a charge sheet. And knowing how clever you are, I was a bit surprised how wrongly you could get this question. But let's look at the truth answer. Question 4C. I cannot see read here. Republic of Kenya, Chief Magistrate Court, criminal case number between Republic versus Kichwangumu, not a prosecute. Not a prosecute. You quote Article 157, and of course section are you Ruth? Ruth, how are you? You can hear me?
Yes, I can hear you now.
Sawa sawa. I was looking at how you did this question on not a prosecute. Of course, you quote Article 157 of the Constitution, which is on the DPP, and section 82 and 87. That is very correct. How did you conclude this is a chamber summon?
Let me be honest. I looked for a sample of prosecute. I got nothing. So I just knew that introduction. And I was like, if I'm introducing something, maybe it looks like a chamber summon, but I don't know how it's supposed to look like.
The general rule in criminal matters is of course, even me, I was trying to look at this DPP people. There's a friend of mine I've asked even this afternoon. They usually say they do this application orally. Yeah? They don't have even
when you look at the case law, when you look at the case law, they just say made an oral application or not prosecute and gave a reasons why. I looked for what.
Sorry?
This is private prosecution.
No, not a prosecute. Not a prosecute. It's not a prosecute. So, I asked someone in the DPP office they told me the same, but I'm going to still I'm going to search more for an application. Even I can go there because they are just near where we work. But if we say that in criminal matters where the rules that do not say, even in civil procedure, you see, the general rule is that where the rules are silent on the application to use, usually use notice of motion. And but of course, where the rules are expressed, like habeas corpus, they say use a chamber summons. The habeas corpus rules, you use a notice of motion. So, pending my investigation on the application that should be used, of course, from further getting a sample from the from DPP office. It should be a notice of motion, not a chamber summon. Chamber summons is very specific, where the rules say, even in the civil procedure rules, you remember I stated you the instances where you use a chamber summon, and it is very expressed in the rules. So where the rules are not expressed, you use the default is notice of motion. But we can take other details. That the application be certified as urgent, and the applicant be given leave to enter, not prosecute, which application is based on grounds that we say that here on application based on the grounds that you put in the pleading should be legal grounds, not factual things. That the applicant be presented in witness in court initially, occasion frequent incursion by the Al-Shabaab. Those are factual issues. You put them in the affidavit. That the last witnesses testified was in 4th May. Those are factual. That the key witness gave evidence in chief but could not be examined owing to shortage of time. That that the leave be that it would be justified if the leave it should be granted. So what are the legal grounds that the prosecution may move the court for them to issue an error prosecute? This is what you should put here. For example, you can say Article 155, this where you have stated and Article 157(6), it says (156)(b), 156(b), on the grounds that the DPP can uh, 157(6)(c), discontinue. The DPP can discontinue at any stage before judgment is delivered of any criminal proceedings instituted by him. Then another grounds you put is 157.8. The director of public prosecution may not discontinue a prosecution without the permission of the court. And that's why they usually put this application. You know, before the 2010 constitution, they were terminating the cases before without reference to court. Those are the legal grounds you put here. So the grounds which are the grounds are legal grounds. Then the supporting affidavit. Now you put all the story why you are terminating the question. I am an advocate of High Court attached to the Office of Director of Public Prosecution. Of course, another ground that you put here, legal grounds, you can put 157.9. The powers of Director of Public Prosecution may be exercised in person or subordinate officers in acting in accordance with the general specific instructions. Are we together?
Yes, we are.
Yeah, so
Yes.
you put, sorry?
I have a question, Mwalimu.
Yes.
When you're doing the supporting affidavit,
Yes.
we're supposed to give factual. Can you quote a case law?
No, you can't.
No.
You
can't quote.
You supporting affidavit. If you look at orders 19 on affidavits, it must be factual issues, which you know yourself as the person who is doing the affidavit. Unaona? And it is not best to you don't quote a case law. Case law you quote when you are doing submission. Are we together?
Yes.
And if it is of course, this is a counsel you are counsel, but if it's a lame person who is doing a supporting affidavit, if there are legal issues, you don't expect a lay person to know legal issues. So that's why they usually say, I've been informed by my advocate on record, information which I reliable believe to be true. Unaona, that for the legal issues. Have you seen affidavit like that?
Yes.
Yes, so that I am prosecutor attached to the office of DPP, that the case has not continued for 1 year in the security in the year Chabab, that the witnesses are not be able to give the witnesses testimony or cross-examined. Of course, that is the reason. Then you give the story that this person was killed on this date, according to the question, that we believe that the accused herein was involved by the murder of this person, that we pray for this case to be halted because the police are investigating the possible involvement of this person. His name is there for possible crimes. Then that what is deported is true. So doing an affidavit is usually not a problem because the factual issues are usually in the question, but the pleading itself is where the problem is, because of course you must know the pleading, its name, the provision that you are bringing the pleading on, and the prayers you are praying, which of course they are not hide, but then the grounds which you are bringing the application on must be legal grounds. And of course, if you are not sure about the legal grounds, in an exam scenario, you can leave them, go straight to the affidavit. But
I have a question, Mwalimu.
yes.
Now that we've stated if there's no rule, you do a notice of motion. So does I have to cancel this nolle prosecute and put notice of motion?
Yes, you do a notice of motion. I said the general rule where because there's nowhere under our rules where it says you use a chamber summon. Chamber summons are very specific. So where there is no chamber summons, where you have not been told in the rules what application you use, the default is notice of motion. So the answer here is notice of motion. But I've said pending to my further investigation, I'm going to consult some. I'm going to go to the DPP office myself. You know, I have so many applications here. I went to court and I got them. So this one I'm going to go physically to the DPP office when I get time, and I'm sure I'm going to get the further direction. But for now, know that is a notice of motion, and I've written down here. If in any case, if it is changed, I'm going to tell you. Are we together?
Yes, Mwalimu.
Yes.
And we said the other bail pending appeal. For your Ruth, for your information, we say that you do notice of course chamber summon. If you look at the cases, there's someone who used a chamber summon in KRR website, but most of the cases, if you look, they are done by notice of motion. So in an exam scenario, don't do a notice of motion and don't do a chamber summon. So in any civil pleadings or criminal pleadings where the rules does not state expressly you use a chamber summon, the default is notice of motion. Are we together?
Yes.
So we go to the next question, which will be our last for today. Then we are going to do the others next time. So so the next question is question 4B, November 2013. If you see the way, if I've uploaded wrongly, I've given you guidance that the question that we are dealing with this during this time are between topic 9 and topic 9, which is pre-trial conference, trial, the trial process, all of it, then revision, then appearance, jurisdiction, appeals. Those are the topics we are dealing with during this time. So if you see a question that I've given you, if you see I've given you the question that is not dealing with those 4 areas, those areas, you can ask me, because now we are dealing with those topic 9 to 12, 2023, 2024 course outline. So we go to our last question of the day, which is question 4B, November 2013. And I want to open the question now. November 2013. It's opening. OB November 2013. OB November 2013. November 2013. 2013 is on your screen. Of course, the question is very direct. Assume you are judge before whom the application for bail made and pose and summarize above. Write the reason for the application. So we are dealing with on how to write a judgment or a ruling. And you can be told to write a judgment or a ruling on any legal issue in any topic. And let me now read the facts. So it's also when you are dealing the ruling, when you are dealing with judgment or ruling, remember in civil litigation, we said that you must know the legal principles that are asking about the questions, application for bail. So you must know the legal principles on bail for you to do the ruling and or the judgment. And you see, I said in our civil litigation class, not only are you should, or would you know, of course the issue is whether the person been given the bail. Even before I read the question, your analysis must know, of course, the legal principles that apply when bail is being supposed to be given. Then you can apply the analysis very well, but you still you after the analysis, the examiner will want to see your orders which you give, because you can do a very good analysis and still fail, give bad orders or orders which does not reflect on your analysis. So on 30th, on 3/2013, Mr. Bahati Naisibu was arraigned before High Court at Nairobi in criminal case 33 of 2013 on charge of murder, contrary to Section 203 as read with Section 204 of Penal Code. It was alleged that Bahati Naisibu, the accused that one on at Upper Inner Estate with Nairobi in the Republic of Kenya, he murdered Miss Maimuna Cheusiku. The accused pleaded not guilty and he was remanded in prison custody. On 22nd February 23rd, in Exaward described absolute right to bail. The accused filed an application to be released on bail pending appeal. In an exam, if you are told to draft an application for bail pending appeal, pending trial, you do a notice of motion, and I think this question have been asked, and supporting affidavit. You now say, and now state the principles. The state fervently opposed the bill application through an affidavit signed by investigation officer, Police Sergeant Fares Doya. According to Doya, the accused are living with Cheusiku is in the formal relationship, and that after killing Cheusiku, the accused telephoned her father and informed him that he accused had killed his daughter and has got and collect the body from the house for burial. Cheusiku father went for the body, which he found a pool of blood on the floor of the bedroom, but the accused was nowhere to be found. Eventually, the accused was arrested on that date at Maraba on Kenya border. By the time the accused was found in possession of Uganda identity card bearing his photograph and the name of Juma Richard, the court was told that the accused home was short distance from the border and that he was likely to abscond and leave the country if granted bail. The prosecution has asked the court to consider the offense was committed on February 20, while the accused who had disappeared was arrested in March 2021. According to prosecution, was evidence that he was hiding, and the accused conduct demonstrated he was keen on absconding. The defense argued that there was no evidence advanced in court that the accused was likely to run away. And this was not the offense of the accused to be arrested near the Kenya-Uganda border, which was his home. Assume you are the judge before whom the application for bail was made and oppose and summarize above. Read the reasoned ruling on the application. It was a ruling, not a judgment. So you must be knowing the principles that an applicant must prove so that he can be given bail. And so I want to see your argument, how you wrote the ruling. So I'm on Ruth pleading. I don't know the time you used to do this. You are not indicating your pleadings, the time you used to do them.
No,
Please
I
be,
did. Yeah, maybe it's because of the photo, but I did.
20 minutes, eh?
Yeah, that was 20 minutes.
20 minutes for a question of 9 marks. That means a question of 15 marks, you should use that 8 minutes. A question of 20 marks, use 50 minutes. A question of 10 marks, you use around 25 minutes. So you are on time. That's good. Now we see your pleading. Republic of Kenya in the High Court of Nairobi, criminal case. Of course, Nairobi, yes. Number 33, you could put the case number. That is correct because it already have a case number. Of course, it's given in the question between Bahati Nairobi applicant and the Republic. Bahati Naisibu. You can put this way. You can put this away. You put the way the accused was charged. So it's Republic versus the Bahati, the accused. Are we together?
Yes.
It does not change because you are making an application. It is the Republic as the applicant and the accused. Bahati Naibu the accused. So that you correct. So ruling, pre-facts. The applicant was arraigned in court in charge of contrary to section 2.3. We say that you put the brief facts as brief as possible because you not waste a lot of time because these brief facts are already in the question. But contrary to section 203 as led to as penal code, the applicant pleaded not guilty and was remanded in prison in custody. The applicant applied to be released on bail pending trial. That is okay. Applicant case. The applicant that the absolute right to bail, it was not required to be arrested in the Kenya border. Respondent case. That's okay. The respondent opposed the application through an evidence owned by the investigation. The applicant committed the murder and was arrested at Malaba, Kenya border, and the prosecution got an identity card bearing his photograph. And Richard Disden was from the border and was likely to abscond. Issues whether the applicant, where the accused should be released on bail. You change there. It's still the accused, where the accused should be released on bail pending trial. Or you can put whether the accused applicant should, whether the accused stroke applicant should be released on bail pending trial. Analysis. The right to bail Pediatra is provided for in Article 49 of the Constitution. An accused person is to be presumed and sure until proven guilty. In Section 20 and 21 of the accused person are right to be released on bail, but the right is not absolute. In judicial bail and bond guidelines, it is provided for principles that should be considered before granting bail. The principles were also highlighted in Carissa versus Republic. The factors should be removed: severity of the crime, the nature of the offense, where the accused may escort bail, the security of the accused, whether the accused engage on the offenses. I can't please be scanning good things, like Marianne. Are we together, me and the rules?
Yes, I think I'll have to regulate the lighting.
Yeah, whether the accused, you can read from here. So you have the answer.
Let me read for you. Let me read for you. Okay, when it comes to D, go up, Apple. The security of
accused.
Yes, now D. The security of accused when released. Security of the victim if accused is released on bail. Whether the accused may engage in other offenses. Whether the accused would interfere with the case by interfering with witnesses. Then we go to determination. In this matter, the respondent claimed that the accused.
You can put it. You can. You see, instead of the word determination, so that is does not confuse with the last. It's better use the word analysis.
I'd used analysis before.
Yes, use analysis, because of course also determination is okay, but the better word is analysis. So because now as a judge you are analyzing the law and the facts, so you will be putting here analysis. Sawa?
Yes.
Continue, read.
Okay, in this matter, the respondent claimed that the accused live in the border of Kenya and Uganda, and thus he can abscond bail. The offense is of a capital offense, which is severe, which carries a severe punishment of death. The accused has a fixed abode at the border of Kenya and Uganda. He was found to possess an Ugandan identification card with his photograph and the name Ojuma Richard, which may indicate his intention to flee the country to Uganda. Conclusion: the possession of a Uganda identification card with a name not his own indicate the likelihood of his intention to flee to Uganda. The applicant has not brought before the court evidence that he has dual citizenship. Then disposition: I hereby determine that the bail application has been denied for the risk of absconding. Then dated this date and Judge RWM.
Yes, that is that is the correct determination. So instead of putting conclusion here, you are still doing the analysis. So this one, you remove conclusion, is still in the analysis. You are still doing the analysis. Then you disposition. You can I hereby determine the bail application have been denied for the risk of absconding. So disposition order. So that's so correct. So these principles that the court usually uses in determining bail should be in your fingertips. And I told you you should, when you're doing this question, be as honest as possible. Don't look anywhere. But you did the question generally well, except for those minor amendments. So you look at the rules question analysis, ruling. The ruling on bail, Republic of Kenya, High Court of Kenya of Nairobi, criminal case 33 of 2013, Bahati Naibu accused applicant. You see, what I was telling you. you exchange here, okay, accused applicant, republic, and the respondent. Ruling before this court is an application dated 22 February 2013 by applicant counsel hearing the applicant's admission of bail pending trial. The applicant asserted his right to bail under Article 41H of the Constitution, which provided for right to be released on reasonable bail on pending trial. In opposition to the application, the prosecutor submitted that the right to bail is not absolute and relied on the fact that the applicant was charged with murder and a serious offense that carried a sentence of death and the inclination of the accused to abscond, having disappeared 1 month after commission of offense and being arrested near Kenya border. I've considered the application, and it is my view that the issue for determination is whether the applicant ought to be admitted to bail pending trial. You add there, pending trial. Are we together?
Yes, we are, Mwalimu.
Yes. And Article 150, because they are bail pending trial, they are bail pending appeal. So it's very good to specify. And Article 41H of the Constitution, an arrested person has a right to be released on bail on reasonable condition pending trial unless there is compelling reason not to be released. Section 120 of Criminal Procedure Code limits the right to bail if they consider the nature and seriousness of the offense, character, and serious association, and committed crimes as ground not to admit the accused. This position is supported by the bail and bond policy guidance under Section 49. What arises is that the right to bail is not an absolute, where the compelling grounds. The question now is whether the prosecutor has raised compelling reason. The prosecution reason as to why the accused ought to be denied bail is that the murder is a serious offense that carries serious punishment and that the initiative to abscond. The accused has also already attempted to abscond, raising question of the accused person's character. I find merit with the prosecution argument. The offense of murder is a serious and the punishment heavy, which causes the court to assume that the more probability of the accused to abscond. I here dismiss the application and deny the applicant admission to bail, dated and delivered at Nairobi this date of 19th November 2019. You are assuming that you are the judge. Yes, Nyambura Cheni, judge of the High Court. So that was okay. You both did the application well. And you are going to start there next time. But Ruth was not there. I said that the doing examination in chief and cross-examination and re-examination question, you have not perfected the art. And I'm going to give you questions, which of course are in trial advocacy questions. It has them for our next class so that you perfect the examination in chief and cross-examination. Cross-examination, you are trying to put doubt to the prosecution witness what he said, and you can read him or her. But in examination in chief, you can't give them reading question, and the examination in chief is you are building your story or the theory of your case. For example, you see on your screen, this is a question in your year 2000, and you see that in your trial advocacy. This was a question. This is a bill structure of examination in chief of Tiffany, a prosecution witness. Your Honor, the prosecutor wishes to call the complainant Pier 1. You may proceed. Witness take court. Kindly introduce yourself to court. My name is Tiffany. Of course, if you are told draft examination in chief and the answers, that's how you draft. My name is Tiffany. I'm the complainant. What complainant is before the court? My complainant is that on the morning of 15, the accused person, Jeff, a former worker in my farm, stole my tractor. Prior to filing of the complaint, did you know the accused person had previously been convicted of a robbery with violence? I was not aware. Now you know. When did the shocking heinous death by the accused take place? On 27 January. Was it not? So I want you to perfect the art of writing this examination in chief questions. So I'm going to give.
Mwalimu,
Yes.
okay. I based on how we are taught by, mine might not be perfect, obviously, but based by what Mr. Mwaniki teaches us, in examination in chief, you can't use those deeds. You have to use the 4 wives and 1 husband.
Yes, yes. Of course, that is a question. This is a question. Of course, it wanted you to poke holes. Why that is a question, not an answer. So even I should not have shown you. But
yes.
Yes. So I saw that you are Nini. You had difficulty. I saw Berian had difficulty in doing this question. And let's just do one other text before. I'll just give you one test.
Okay.
Then we are going to be the first thing we are going to do next class. And when you are doing this, you're also dealing with trial advocacy.
It's true. Alafu mwalimu, I have an issue with appeal when you're appealing. Okay, in criminal court, in criminal matter, I know you do a petition of appeal. Now that is to High Court. Now what happens to Court of Appeal? Because now when you look at civil now we start talking about notice of appeal and memorandum of appeal. Now when it comes to there, when now comparison of the two, I am having an issue slightly.
We are going to look at that because you are going to look at that before we reach there. But you see, everything is in the for criminal appeal to the Court of Appeal. Look at the Court of Appeal rules. It has both civil and criminal. You start with the notice of appeal, and which they must file within some days, and then memorandum of appeal. Everything is in the Court of Appeal rules and the Appellate Jurisdiction Act. Are we together?
Okay.
For both criminal and civil, but those things we are going to Nini. We are going to have sometimes on appeals, because that's another very sensitive area, and I'm considering also to increase the frequency of classes.
Okay.
Let me stop this